Hey everyone, welcome back. Today we're looking at the early courtroom proceedings in the case of Commonwealth versus Lindsay Clancy, where the court addresses critical pre-trial motions rather than the facts of the crime itself. This hearing focuses on logistics, medical and mental health considerations, transportation arrangements, discovery of medical records, expert evaluations, and how the court plans to manage a highly complex trial ahead. With the defendant appearing by Zoom and both sides debating ADA compliance, medical needs, and trial readiness, this session sets the groundwork for how this case will move forward toward its scheduled trial date.
This court is now in session. Please be seated.
Good morning again, Your Honor. Good morning, all. Before the court is the case of Commonwealth versus Lindsay Clancy, 2383 CR 198. Just looking to see if we have Ms. Clancy in the Zoom. Just a second, Mitch. Ms. Clancy appears to us by Zoom. Counsel for the record, please. This case is called for motions. Commonwealth first.
Good morning, Your Honor. Jennifer Sprague for Commonwealth.
Attorney Sprague, good morning.
Good morning. I believe Attorney Kenny is on her way upstairs now.
Okay, all right.
And Shannon Buckingham also for the Commonwealth.
Attorney Buckingham, good morning.
Morning, Your Honor. Kevin Reddington on behalf of Lindsay Clancy, who, as you know, is on the Zoom with us.
All right, Mr. Reddington, good morning. Ms. Clancy, good morning. Can you hear me all right?
Good morning, yes, Your Honor.
Okay, thank you. All right. So this is really kind of a continuation of the discussions that we had yesterday. And what I wanted to do was kind of give you where I think we're going to go, and then see that we can go right there. One of the first things I want to talk about again is transportation and logistics issues, how we're going to do that. Then I want to go over medical records, kind of where we are in regards to discovery. Then I want to kind of see where we are in regards to the examination of the defendant by the Commonwealth's expert. And then I know there's a Rule 17 motion we have to talk about, and then talk about other needed dates before the trial. And the last thing that I will probably mention, so everybody has in their head, is the date to provide an updated joint pretrial memo, because I think that's going to be very helpful, at least for the court, in regards to preparation. And so I think the first thing that I would suggest bringing up is the transportation and other related issues in regards to it. I know we talked a little bit about that yesterday, but that was more, I think, in the frame of it being an emergency issue about whether or not Ms. Clancy was brought in today.
The court reconvenes for Commonwealth versus Lindsay Clancy, with Clancy appearing via Zoom, as attorneys discuss transportation logistics, medical records, expert examinations, and pre-trial deadlines, focusing on how to safely manage her presence at court. How do you think courts handle complex logistics for defendants with serious medical needs during a trial?
We can now kind of take more of a deep breath and talk about kind of where we go. I know so Attorney Kenny's here as well, and so why don't I hear from Attorney Kenny, if we would, as to what kind of what the Sheriff's Department thoughts are, or proposed plans or procedures, how they would follow in a case like this.
Good morning, Your Honor. Jessica Kenny on behalf of the Plymouth County Sheriff's Department. As I represented to the court previously, we were forwarded the HABE to bring the defendant to court in this matter a couple times previously. It gets sent to Tewksbury, but because she's also held without bail on the murder charges, Tewksbury sends that to us. I originally thought that might have just been because of the murder charges, but as I learned and explained to the court yesterday, I apologize, I have a cough drop in my mouth. I just have a little cold, so I didn't want you to think I was eating food.
I kind of pulled you right out of the audience.
That's okay.
Unexpected as well. Thank you.
As I learned yesterday, it's also essential because Tewksbury Hospital doesn't have the ability to transport, nor the security to be able to do it either. So, as I indicated previously, the last time we were sent a HABE for her appearance, we received that from Tewksbury Hospital with a note that her medical information would follow It did follow with a fax from Tewksbury that explained the nature of some of her medical needs. In light of receiving that fax, the transportation supervisor reached out to me and to our HSA, who is our health services administrator, and asked for a little bit more information to make sure that we could meet all of her needs. So our HSA, who was in court with me on the last date, did reach out to Tewksbury Hospital and spoke with someone there who provided just a little bit more background information about the medical necessity that would be required. And based on that information that we received, we understood that we could transport her in a van that we have that has been equipped to hold a wheelchair. It's a regular transportation van that we had, and about a year after we purchased it, we had it outfitted by a company specifically that does that to make it so that it can be used or utilized with a wheelchair. We had also indicated that based on the information we received from Tewksbury, we had no objection to sending a nurse along with Ms. Clancy. The information we had received from Tewksbury was that, likelihood she could handle any care matters that came up, but in the event that she did need some medical assistance, we thought it would be prudent to send a nurse along with her for that transportation. And so that was our plan based on the information that we had from Tewksbury. Obviously, since that occurred, I have received from Mr. Reddington an ADA request that he filed with the court with documentation from a psychologist, I believe, that has been seeing Ms. Clancy, that indicates that any sort of custody situation would create a sense of helplessness and loss of control that could trigger some mental health responses from her. I'm also in receipt of a 2-page letter, I believe it was just yesterday or Monday, that was forwarded to me, that instead indicated that she may actually need a stretcher and that she would need 2 nurses to accompany her. And it had some more detailed medical information. So before I had received those, like I said, based on our communications, that was our plan. That's all the information that I have regarding that. I only obviously have what Tewksbury shares with us and then what I receive from her counsel separately or from the court in pleadings.
Attorney Jessica Kenny from the Puma County Sheriff's Department outlines the plan to safely transport Lindsay Clancy, explaining that Tewksbury Hospital cannot provide transport or security, so the Sheriff's Department arranged a wheelchair-accessible van and planned to send a nurse along for assistance, though new medical information and an ADA request now suggest she may need a stretcher and 2 nurses. How should courts adapt logistics when a defendant's medical and psychological needs evolve during trial preparations?
If it is still the case that Tewksbury believes she could be in the wheelchair van, we are able to do that. If she requires an ambulance, I've spoken to our transportation officer about this. It's a much bigger ask. We would have to contract with a private ambulance company to provide that, because we do not have an ambulance, and Tewksbury does not have an ambulance. So there would be certainly a cost associated with that. There's also some logistics, is that the scheduling of an ambulance obviously can sometimes be a difficult thing given the nature of what ambulances are. I don't know if we would require the ambulance, the court would require the ambulance to stay at the courthouse the entire time that Ms. Clancy was here each day, to make that stretcher available to her if she needed it. If the ambulance were allowed to leave, it would then require the trial court officers to reach out to the Sheriff's Department, to reach out to the ambulance company to send the ambulance back. And obviously that would have to occur, if that's what the court rules that she needs for transportation, that would require us to arrange that every day of her trial for the duration of that trial. So we do not have another way to transport her if it's not in a van that can accommodate her wheelchair.
All right, thank you. Let me ask if, in regards to the information that you received from Tewksbury, not considering the psychiatric concerns that were raised in a separate motion, would the Sheriff's Department be able to provide the care or the supervision that was kind of spelled out in that letter from the other day?
So that letter from the other day seems to indicate that she would need a flat surface, such as a gurney, I believe was an example. So we don't have a van that could accommodate a stretcher. So if she needed that during transport, it would be an ambulance. If it was a matter of getting a stretcher to the courthouse so that she had it here available, I can talk to our facility about whether we have some sort of medical bed that we could make available to her here. If she requires if the court finds that she requires 2 nurses, obviously that's a little bit more of a strain on our staff, as we would be then required to pull 2 nurses out of our medical unit in the jail. So I did actually briefly mention yesterday when I was speaking to the attorneys from Tewksbury if maybe they would be willing to split that with us, and maybe if they may be able to send a nurse from Tewksbury and we would send one from the House of Corrections, so there could be 2, but neither of our, because they also expressed concern about pulling 2 nurses off of their floor as well. And I know they're at least open to the idea of talking about it. It would probably involve conversations with the attorneys from DMH, because there are some union and labor issues that we would just have to work through individually with the individual departments. But it wasn't foreclosed when I brought it up yesterday. If the court does order her to have 2 nurses with her, perhaps one could come from the House of Correction and one from the hospital setting, so that neither is really shorthanded. I know this would probably be a lengthy trial, if I understand. And so it's just it can be done, but it would just take some planning. That's all. We're hoping to get an order from the court well in advance. So
I was going to say, an advance order would be...
Yes, especially if there's going to be an ambulance involved, because that, in fact, yesterday we tried, in case the court didn't allow her to appear on Zoom today, we tried to see how we'd be able to maybe get an ambulance for today, and we had struck out on all of the attempts that we had made. So advanced planning is key if there's going to be an ambulance involved and if there's going to be more than 1 nurse involved.
Okay, all right. Thank you very much. I appreciate the input.
The Sheriff's Department explained that while a wheelchair-accessible van could handle transport, arranging an ambulance would be far more complex, costly, and logistically challenging, requiring daily coordination and possibly multiple nurses for Clancy's care. They discussed potential staffing solutions, including sharing nursing duties with the hospital, but emphasized that advanced planning and clear court orders would be essential for her safety during the trial. How can courts balance logistical constraints with the need for specialized medical support for a defendant during lengthy proceedings?
Mr. Reddington, what suggestions or proposals would you suggest the court implement in regards to the transportation, as well as while Ms. Clancy is here during the trial date?
That whole presentation is, as the old song back in the 70s, is Radio Gaga. It doesn't tell you anything. The last time that counsel for the sheriff addressed this court, I got off of FTR the representations that were made to this court. That led to my filing the Rule 17 motion, which I think is central to the issues that you, and I don't envy your job, because this is a nightmare. This case is going to be a logistical nightmare. When you consider the facts that, number one, we have a person who is paralyzed and will be paralyzed for the rest of her life and has lost any sensation and any motor control whatsoever, and I am referring to the January 2nd, 2026 letter that I obtained from the physician's assistant who knows Ms. Clancy, who has been involved very, very deeply with her treatment and care, indicating that she lacks both sensation and motor control below the sternum, breastbone. When we had our hearing and counsel for the sheriff made representations to you, first of all, one of the things that was said is that it would be apparently the sheriff health services administrator, and I quote, reached out to the medical team there and learned that Clancy is confined to a wheelchair. However, she can self-transfer and can provide self-care in virtually all aspects of a day trip like this to the courthouse, The only thing Tewksbury was requesting was that we transport her via wheelchair van, which we do have one of those vans available. Which begs the question, first of all, as my Rule 17 motion, I did an investigation, and I don't know who the heck they talked to from Tewksbury, but that's not the information I'm getting from Tewksbury. So I filed a request. Number one, I want a copy of the signed HIPAA form. That is a law. It's a federal law. We all know it, and it means something. That a person has to sign an authorization before people can willy-nilly make phone calls and talk to people about somebody's physical condition, mental condition, dealing with medical records and things of that nature, which apparently was done here. There's an awful lot of representations made to the court about someone from Tewksbury.
Let me stop it. What if I think some of those representations and positions were made before the December letter from the physician's assistant. And if I have that information from that letter that was provided by you to the court, as well as to the Commonwealth, my thought is that seems to be more representative of what the condition is. And I'd like to go forward if I adopt that opinion.
The defense argued that transporting Miss Clancy to court is extremely complex due to her permanent paralysis and complete loss of sensation below the sternum, as confirmed in a January 2, 2026 letter from her physician's assistant. They challenged prior claims that she could self-transfer and care for herself on a courthouse trip, emphasizing that accurate medical information and proper authorizations, like a signed HIPAA form, are essential for planning her transport and care. How should the court ensure accurate medical facts are followed while arranging safe and feasible logistics for a disabled defendant?
The question I'd have is, what are the arrangements consistent with that medical condition that's set out in that letter? That's kind of where I'm at right now.
Understood, and I appreciate that, Your Honor. And facts and identification of the source of the facts are important here. You don't just reference someone from Tewksbury. In my Rule 17, I asked for identification of the person who is the health service administrator, apparently, for the sheriff that spoke to someone from Tewksbury about the day trip to the courthouse. I want to know who it is that worked for the sheriff's department that talked to them in Tewksbury. As I said, I want to have in my order a copy of the HIPAA form that was signed by Ms. Clancy, which I know and I represent to the court was never done. I want to know the identity of the person from Tewksbury who allegedly advises that she is capable of providing self-care in all aspects of the day trip to the courthouse, and that all they wanted was a transport via wheelchair. You take that letter of January 2nd that was addressed to whom it may concern, which unfortunately is you, because you are the one that ultimately has to decide the logistics of this case. And it is nightmarish. We are going to be in a situation where we have a woman who is paralyzed from the sternum down. Your Honor is well aware that she has no control over any of her bodily functions. Your Honor has the letter that describes in detail the requirements, and I know the letter's under seal, and just out of interest of trying not to get into embarrassing issues here, it's incredible the medical care that is necessary for the duration of the trial and periodically during the day. This is where it's advised to the court that she requires a two-person female assist for these issues, necessitating transfers to flat surfaces such as stretcher or exam table. How the hell does she come up with telling you that she's able to ambulate and self-transfer and provide self-care in all aspects of a day trip like this to the courthouse when you have this letter that tells you the condition that this woman is in, requiring two-person female assist for her care, that she has to be transferred to a flat surface, such as a stretcher or exam table? This isn't something that you got from the Sheriff's Health Services Administrator. This isn't something that you got from the lawyer for the sheriff telling you, well, we talked to somebody up in Tewksbury, someone from my office spoke to them. This is hard facts that we're dealing with here. So looking back at the letter, after the transfer to the flat surface, it has to be done on a regular basis. She then has other issues that have to be taken care of, as you can well imagine. She is not able to even use a handicapped bathroom stall. She has to have extra supplies available. She has to have a nurse that's not a veterinarian that knows what the medical condition of the individual. Sheriff's Department. We have raised the issue under 123.21. A person who is mentally ill, who has been committed, if you will, to the care, custody, and control of the Department of includes the sheriff. Illness, 2 or purpose authorized under this chapter shall not use any restraints that are unnecessary for the safety of the person being transported or anyone likely to come in contact with the person. I've also requested ADA assistance. I researched into it and found that there is one form that is supposed to be used in the Superior Court in the Commonwealth of Massachusetts or any of the court systems in the Commonwealth of Massachusetts.
The defense emphasized that Miss Clancy's medical needs, as described in the January 2nd letter, are extensive. She is paralyzed from the sternum down, requires 2-person assistance for transfers to flat surfaces like stretchers or exam tables, and cannot manage basic self-care. They questioned prior representations that she could self-transfer and travel in a wheelchair van alone, stressing that accurate identification of the medical sources, proper HIPAA authorization, and ADA accommodations are critical for safe courthouse transport and care. How can the court arrange transportation and in-court support that fully aligns with her documented medical condition while ensuring legal and logistical compliance?
That form was provided by the committee, as Your Honor knows, that is dealing with the Americans with Disabilities Act. She's an American, she's presumed innocent, she has a disability, she comes squarely under the ADA. I filed the request with this court. Counsel for the sheriff indicated that I didn't ask the sheriff. I filed it randomly with the court. No, it wasn't randomly with the court. It's what was required by the Superior Court ADA. So I did file, ADA meaning Americans with Disabilities Act. I did file that request. So now we're dealing with 123.21. We're dealing with the ADA. And it does apply to this court. So my suggestion, Your Honor, is that I need to know who it was that they talked to from Tewksbury, because I want to interview that person. I want a copy of the HIPAA form, which I know they don't have, and I want to know who the person is from the Sheriff's Department that made these representations to Attorney Kenny, because Attorney Kenny, I'm sure, is relying on what was provided to her. So you, I think, have to have a hearing. Now, a hearing might entail evidence from the physician's assistant. Maybe it would require evidence, I don't know, maybe you have an independent evaluation. This whole thing raises issues of competence to stand trial. How's a person going to be able to go through the horrific emotion of this case for 3 to 4 weeks on a daily basis with these medical issues of significant concern, not to mention the fact, as is indicated again in the letter, which gives you the hard facts that we're dealing with, that she has significant suicidal ideation. That since she has been in custody, care, and control of DMH, and has been in Tewksbury, for example, she is on 24/7 watch by a third party. A person has to observe her. She cannot have access to anything that she can use to hurt herself. She's not a danger to others, that's for sure, but she's surely a danger to herself. So all of this, people telling you, well, Judge, you know, we can put her in the lockup and we can put her downstairs and we can move her up to here. It's not on me. If this woman kills herself during this trial, which there is a very real probability that could happen, it's on somebody and it's not on me, because I'm coming in here with names, reports, facts, medical and psychiatric issues, and unfortunately, it all lies at your table because you are the judge that has to determine the logistics on this case. So that's why I think we need a full hearing.
Commonwealth, do you wish to address the court?
Yes, Your Honor. So, defense counsel referenced Chapter 123, Section 21, but what it states in the very beginning of that statute is that it applies only to the transport for any purpose under that Chapter 123. So that's basically someone committed under Chapter 123, and you're transporting to court to address those issues. This is clearly not that situation where she's going to be transported for a murder trial, a criminal case. So I suggest that the items listed in that statute describing how and when you can have someone confined or restrained don't apply here. In terms of the HIPAA form that defense is asking for, this woman is a prisoner held without bail on these charges and is in the custody and control of the sheriff's department, so they have every right to access her medical information because they're responsible for her care and treatment and keeping her safe, which they have done an excellent job up until now, and I assume they will continue to do so. Now, the letter from the physician's assistant, dated January 2nd, 2026, never states that Ms. Clancy has to be transported in an ambulance.
The defense argued that Ms. Clancy's ADA rights require careful planning for her courthouse transport and care, highlighting her paralysis, suicidal ideation, and need for constant observation, and requested identification of Tewksbury sources, a HIPAA form, and possibly a hearing. The Commonwealth countered that Chapter 123, Section 21 doesn't apply to criminal trials. The sheriff has lawful access to her records, and the January 2nd physician's assistant letter doesn't require ambulance transport. The question is, how should the court balance ADA protections, safety, and logistics to ensure her care during the trial?
Never says that she has to have a stretcher for transportation. What it says is for bathroom needs, she requires the 2 females and a flat surface such as a stretcher or an exam table. So I think that the initial what's in this letter and what was initially described to Attorney Kenny is correct, that she could be transported in a wheelchair van, but we now have the additional information that we need, 2 medical staff present and some type of table, which I think we could probably rent something, you can rent medical equipment, so I think the court could arrange that, or the sheriff's department, however you order it. And the defense had mentioned how Ms. Kenny was able to come up with this information about Ms. Clancy being able to take care of herself. It's right in this letter from January 2nd. It says Ms. Clancy is able to independently transfer between her wheelchair and her hospital bed. So she is capable of transfer and movement, and that is what Ms. Kenny said. We now have this new information about bathroom needs, but that can be accommodated. So I don't think there's any reason for the drama here. There is no need for a hearing here. You have the letter from the physician's assistant. An order can be crafted from that, and the sheriff's department can comply with that. So I think it would be good for everyone to just take a breath and make a plan and follow the plan.
I'd like to respond, Your Honor, briefly. I don't need to take a breath. What I am going to do is make reference to the letter that was just referred to, which is January 2nd, 2026, that I obtained and requested. And counsel just told you that the letter says that Ms. Clancy, and I quote, is able to independently transfer between her wheelchair and her hospital bed. But what was not said is the rest of the sentence, which is that she has not had significant exposure to settings outside of the hospital since her injury and would likely not be able to safely manage transfers independently in unfamiliar settings.
Here's what I'm going to do. I'm going to craft an order based largely on the information that the court has received from the physician's assistant from Tewksbury. And so that's the starting point that I'm going. That's really the only information that I have from one of her care providers that sets out the condition as well as limitations that I have to take into consideration. So I'm going to draft an order, and I am going to distribute it to both counsel on this as well as to the sheriff's department. And we may need a follow-up hearing in regards to that if the sheriff department says we can or we can't comply with that, or if the defendant feels this doesn't address enough the issues that are set out. But I have a very specific report as to Ms. Clancy's limitations and needs. And I'm going to craft to the best that I can in order addressing the needs of transportation to and from the courthouse, but also how we handle the time that she's here, what needs she needs during the trial, and off times if she's in one of the cells. So I'm going to try and draft as specific an order. We've all tried a lot of cases. We know, I think I know kind of some of the things that can happen, and there's waiting time and there's downtime in regards to that. So I'm going to try as best I can, but I know I'm going to overlook something.
The court clarified that Ms. Clancy can be transported in a wheelchair van. As the January 2, 2026 physician's assistant letter confirms, she can transfer independently between her wheelchair and hospital bed, but added that she may struggle in unfamiliar settings and needs 2 female staff and a flat surface, like a stretcher or exam table, for bathroom care. The judge said they will draft a detailed order addressing her transportation and trial day needs, circulate it to both counsel and the sheriff's department, and may hold a follow-up hearing if adjustments are needed. The question is, how should the court ensure her medical and ADA needs are fully met during the trial?
And so I think it's going to require at least one more run if everybody come in and say, okay, what do you think? What's the problem that you see? Sheriff's Department, what's the problem that you see? It may require issues regarding staffing. And it may be, if I put in the phrase something like a qualified nurse, the question is what's qualified? That may be something we have to specifically address. But I want to get this done within really the next couple of weeks or so. Because the one thing I don't want is to have everybody here for trial and then have something that we just didn't foresee create a problem. I don't think that is fair to either side, and so I want to avoid that. And I think the best way to do that is for me to it's on me. I understand that. For me to draft this order, circulate it between the parties, and then have one more kind of meeting here to say, do you see a problem? Do you see a problem? Sheriff's Department, do you see a problem? And then get that in place. Then everybody can kind of figure it out. And if it requires getting a second nurse, and it requires phone calls, how we do that? Well, or not we, how they said it, or the getting a gurney or getting a stretcher that we can place in one of the cells on this floor, so it's not in the floors downstairs. At least then we can get going on that. It's not something we have to do the first day of trial. So that's what I'm going to do on this. I'm going to take a run at drafting his order as best I can, and then, but everybody should rest assured that that's not going to be the end of it. The parties will have an opportunity to kind of respond to it, and I would welcome suggestions. If someone says this is a better way to do this, or this is not addressing something we thought of, but at least that'll give us a starting point. And like I said, I have now a very specific report in regards to the defendant's condition and needs and limitations. So I'm going to take those into consideration. I'm also going to review it in regards to ADA compliance. I know that I have started to look into that in regards to that, but I think this may address those issues. So I want to make sure that the order I draft also is consistent with the ADA. So that's how we're going to deal with that. The next question that I had, there was some issues regarding some medical records from Tewksbury Hospital that I know we discussed, maybe a couple of months ago. My understanding is that those records are now in. And it's also my understanding the original order was that both parties could have access to those records. But they are in at this point, as I understand, but I checked the docket. So they're there. Parties, they signed a protective order today so that the parties can have them, can have access to them, and get copies of them. And so I don't know if that addresses that part of what we were talking a little bit about yesterday. Commonwealth?
Your Honor, I think under the rule that the records were requested under, the experts requested them through the court, and they were supposed to be sent by the court to the experts, but I have a copy now so I can send them. That's fine.
Yeah, I think that's probably a more efficient way to do it. Any objection to the Commonwealth sending those records to their expert?
No, of course not.
Okay. All right. So if you need an order allowing that, we can do that. But why don't we handle it that way?
Right, and Your Honor should know that I have provided the experts with videos, notes, data, reports, everything from my 3 experts.
All right. All right. Well,
The judge explained that drafting the order for Ms. Clancy's transportation and trial day needs will likely require another meeting to address any remaining staffing or logistical issues, such as defining a qualified nurse or arranging a stretcher in a cell. The goal is to finalize a plan in the next couple of weeks to prevent surprises on the first day of trial. The order will consider her medical condition, limitations, and ADA compliance, and both parties will have the chance to provide input. Additionally, the court confirmed that Tewksbury Hospital records are now available under a protective order and can be shared with the experts, ensuring all parties have access to necessary medical information. The question is, how can the court finalize a detailed ADA-compliant plan for her care and logistics before trial begins?
that takes care of my next question.
Your Honor, I hate to go back to it, but will you consider allowing the request that I had in Rule 17? I'm not sure if you were going to do that or not.
I'm not going to rule on that at this point because I think if we're talking about what information, how the information was gained by the Sheriff's Department or whatever, I have the information that I'm going to rely on, and it's coming from Tewksbury, the letter that I got. And so if there's any problems or dust up regarding how that information was got, that may be for another day, another forum. But I'm going to be relying on that information that I got from the physician assistants, not on anything that the Sheriff's Department provided. Now, the reason I'm not going to deny, I'm just not going to act on it because we still may need more information as to who the individuals are that are going to be required to be present either in the van or the ambulance or here at the courthouse. I certainly think that may be something that the defendant may want to go forward on. So I'm not going to deny that motion at this time.
I also just want to make sure that if I need some assistance, we don't, as I understand it, require an ambulance with all of the accoutrements of an ambulance. I think basically a van with the chair, able to transport the chair is sufficient. I know that Tewksbury has done that on a number of occasions with her, bringing her to various hospitals all over the place for various testings, and they use a van. So I may have misspoken in the sense of an ambulance. I don't need an ambulance with all of the accoutrements.
All right. So I'm going to take, like I said, I'm going to take into consideration the facts that I have in front of me. And I think that's kind of addresses kind of what you're saying. I didn't see anything in there that required the ambulance, but I'm going to take a look at it and review that. So we've got that. Where are we in regards to the Commonwealth's evaluation of Ms. Clancy?
Now that I have the records from Tewksbury, I'll provide them to the experts. The amount of time it takes them, it's voluminous. It's several years worth of records, so it would probably take them 30 to 60 days to go through them. And then they would have to schedule coming here and interviewing and testing the defendant, and then prepare their reports. So we're probably looking at, for all of that to be complete, 3 to 4 months. And those are my estimates. I'm not sure. In the past, they've reviewed the records relatively quickly and efficiently, so I'm assuming they will now.
All right. Just So, a little bit of a, I guess, warning's not the right word. This is going to trial in July. And so this is kind of one of the reasons, and this is not aimed towards either, because I know all counsel will work very hard in this case. But we now have all the records. We've got the experts lined up. We have a trial date, and one of the reasons why we moved the trial date from February to July was that we were going to make sure it's going to get done. So that date's a hard date. So for whatever that's worth. All right. Like I said, that's not a reflection. I know that all counsel are working very hard on this case. In regards to an updated joint pretrial memo, I imagine you're going to need to have the expert's opinion, obviously, before you update that. But I just put that in there because I know we have the trial date in July. Generally, you have, a week or two before that. I think it may make sense to have an earlier final trial conference on this, maybe sometime even in June.
There may be further discovery motions too, Your Honor, that we could perhaps do during March or that type of time frame. So there's some other issues that would be...
Okay. Does it make sense from a next date for a discovery also in regards to any reactions in regards to the transportation order? Like I said, I want to give everybody a chance to weigh in on that.
The judge said she won't rule on the Rule 17 request now, relying instead on the physician assistant's Tewksbury letter. She confirmed an ambulance isn't needed, a wheelchair-accessible van is sufficient, and any staffing needs will be handled in the order. With Tewksbury records available, experts need 30 to 60 days to review, interview Ms. Clancy, and prepare reports before the July trial. Pre-trial conferences and discovery motions will be scheduled, and parties can provide input on transportation. The question is, how will the court handle evaluations, transportation, and pre-trial prep to stay on track for July?
So, Judge, you have a scheduling conference already set up on the 27th
Of
this month.
You want to keep that date?
That's fine.
All right, why don't we keep that? I'll get this order well within that, and that'll keep me on a short leash as well. And then on that date, January 27th, that will be to review the transportation order, the trial logistics, a little bit maybe an idea in regards to the expert timetable, and then I don't know if that would give you enough time to figure out additional discovery. We could argue on that date.
Right.
All right. Well, just at least maybe let Commonwealth know what other kind of areas.
Right. It would just be pretty much, as expected, different experts, other cases that they've worked on and reports or
Just kind of
peer review articles.
I won't say the usual, but expert related discoveries. Is that a better way to put it?
We work well together, so I'm sure that we'll be able to.
So, even if we can address them on that date, even if we're just setting dates for compliance and things like that.
Would the defendant be on Zoom for that next date?
I think so, only because it's not a final order yet. And that's kind of why I'd like to have it earlier rather than later. Then once we get the final order in place, then maybe the day after that, we could have it brought in to see if the order works. If there are any things that were overlooked by me that I have to kind of supplement or amend.
And Your Honor, the defense had mentioned earlier in argument competency to stand trial. Just inquiring now, is that an actual issue? Is he going to request an evaluation?
It's as it relates to physical conditions. It had nothing to do with her intelligence or ability to understand under the Dusky standard, what's going on, who you are, who I am, counsel. There's no issue as to competency in that regard. I'm talking about having a person sitting through an 8-hour trial day for 3 weeks with these issues.
I mean, that's the way I took it.
Okay.
That at this point, I don't have any indication that that's an issue. We've all done during trials, the stress of a trial sometimes affects people differently, and so this would be no different than any other case if that arises. We can address it as it comes, but I don't see any indication, and I didn't take it as any type of notice that was a problem, but I think that was an appropriate question to ask in regards to that. So anything else that we need to address at this time? Commonwealth?
Do you know at this point whether we would be going full days or half days for trial just for planning purposes?
I would probably, I'd like to say full days. But again, there are physical issues that we may have to consider in regards to that. And it also may be a situation, in my experience, we might not be able to start right away, because of if she's coming down from Tewksbury. Sometimes that delays the start of a case. So why don't we say at this point the plan would be full days, but that may change as we go forward.
Thank you.
All right.
The judge confirmed that the scheduling conference will remain on January 27th to review the transportation order, trial logistics, and expert timetables, as well as discuss any additional discovery or compliance dates. The defendant will likely attend via Zoom since the final order hasn't been issued yet. Competency to stand trial isn't an issue. Her physical conditions don't affect her understanding of the proceedings, but the court will monitor how she handles long trial days. The Commonwealth anticipates full trial days, though timing may adjust depending on her transportation from Tewksbury. The question is, how will the court finalize transportation, trial scheduling, and expert review to ensure the July trial runs smoothly? Thank you for watching this case update. If you found this video informative, make sure to like and subscribe for more courtroom coverage and trial insights. Share your thoughts and questions in the comments below. We love hearing your perspectives. Stay tuned for our next update on this case.